this like, they do this every year. We've had it.
Oh, this is good stuff.
Take it, everybody. There's one already. Yeah.
I need one of those.
This is terrific stuff. Oh, yeah. I think this stuff is stupid.
Good stuff.
Buffalo and Washington do it. It's fabulous.
I've never seen it.
Yeah, they did it last year. It's terrific.
Yeah, I don't think it's ever.
Yeah, it's, you know, it's easily readable. It's great stuff.
Good morning, everybody. I'm Jessica LaCroix. I'm the senior advisor at Tenous in Toronto, and I'm going to be chairing the penultimate session of this wonderful conference. To the lay people in the room, I'm sure Michael will appreciate this. This is the girl band warm-up act for the main act at lunch. So today we are going to be talking about U.S.-Canada customs transactions, and there'll be a change to the agenda. As chair, I'm doing that. Instead of the invisible border question mark, it's going to be the invisible border exclamation mark. Catherine will be going first. Catherine Friedman is Director of the Strategic Relations and International Initiatives at the Regional Institute at the University of Buffalo, and she's going to be reviewing her pamphlet, the publication Border Barometer. Cindy, who everyone knows very well from my Mixner, will be reviewing 10 irritants or 10 distractions from border transactions. And Laurie Tenous, who's Vice President, Senator Travelers Trade Advisory Services, will be responding to Cindy's presentation. What we're going to do is we're going to have each of the panelists make their presentations, but I'm going to allow a couple of quick questions in between each of the presentations. I am also going to delegate my bell ringing authority to David Crane, who's been eagerly awaiting having this responsibility. I never got to witness Henry King ringing the bell, and I would like to see how it was done, and I understand that David can carry on this tradition quite well. So before we have Catherine come up, I'm going to transfer the bell to, the official transfer of the bell to David.
I think you said that the maximum time for each speaker is 15 minutes?
Yes.
And the preferable time is 10 or 12?
Yes, because I want to allow maximum time for questions.
Okay.
But Cindy will be giving the most comprehensive presentation. It will hopefully be about 15 minutes. Right, Cindy? Okay. All right, here we go. Catherine, it's all yours.
Are you going to do a courtesy round?
Just one last, yeah, that's the point. You get a vigorous swinging of the bell, and you just have to stop. But 2 or 3 minutes before that, just do one date.
That sounds great.
I wait for 3 minutes in the bottom.
Well, thank you. Thank you very much. And I, of course, would like to thank Dan, as always, for asking me to speak to you this morning and really tee up the panel conversation on regulatory barriers related to the border. As you all have in front of you, the 2010 edition of the Border Barometer. This is a collaborative initiative undertaken between the Border Policy Research Institute at Western Washington University and the Regional Institute at the University of Buffalo, which is where I am based. And the Border Barometer is a tool that provides a U.S. perspective on border performance. We published the first edition of the Border Barometer last year, And in that inaugural edition, we looked at 3 ports of entry. We looked at the Buffalo-Niagara region, Detroit, Windsor, and then the Pacific Gateway out west. And we developed indicators of border performance. In particular, we looked at porosity and infrastructure and came up with data sets that would give us an idea as to how the border was performing with respect to each indicator. This year we've updated it, and we actually expanded the border barometer to 8 ports of entry along the northern border, from Blaine all the way to Champlain, New York, and virtually every major port of entry in between. And then we also, we have the same indicators of porosity and infrastructure, but we added 3 different sections to this edition of the border barometer. We have a section that looks at northern border trends. It highlights trends across the entire border and individual port variation from these trends. We have a section on comparative perspectives. We actually developed several metrics, 4 metrics in particular. And we have used this comparative perspective section to compare and rank performance of each port according to these metrics. And then last but not least, we have individual, as you can see, we have each port of entry in the border barometer has its own 1-page detailed summary or snapshot of performance for each port. So if you want very detailed information on Portal, North Dakota, for example, you can find it in here in the individual port snapshots. So again, I'm not going through all of this data, but I'm just going to give you the broader framework for our conversation. With respect to northern border trends, I think that we all know that trucking dominates commercial exchange between Canada and the United States. And the data that we culled suggests that, not surprisingly to those of you who are in this business, the value of truck exports declined slightly between 2007 and 2008, going from 156 billion to 150.8 billion during that time period. However, what is interesting is that this national or northern border-wide trend was actually driven by 2 ports of entry, by Detroit and Buffalo. At the 6 other ports of entry that we examined, trucking exports actually increased slightly, and you'll be able to see that as you get into the border barometer. Truck exports rose at 6 of the 8 ports examined, but in Detroit and Buffalo, trade flows decreased. And of course, this is most likely due to the economic recession, and in particular the heavy reliance of these ports of entry on the auto industry and auto industry trade. With respect, another data set that we looked at was commodity composition. And because we thought knowing what is crossing the border is as important as understanding how goods flow across the border. In 2008, manufactured goods dominated trade flows. Again, not particularly surprising, comprising 55% of exports and 41% of imports. And again, I think this is something that we all know, but it just demonstrates this point that manufacturing trade really serves as the foundation of our interdependent economies. Next, we looked at seasonal traffic, seasonal truck traffic and auto traffic. We were interested in looking at whether there was any variation throughout the year in terms of these modes of transportation. And we found that there wasn't a whole heck of a lot of variation in truck traffic throughout the year. There was more seasonal variation in auto traffic, and again, it makes sense, for example, in a place like Buffalo, Niagara, where it's actually, if you look on the individual port page, you'll see we have the highest auto traffic entering the United States each month between 2007 and 2008, and it's due in large part to the fact that we have a very strong binational tourism industry, summer homes on each side of the border. There's a lot of traffic going across into Canada and vice versa during the summertime, and it's really reflected during the summer months. This particular graph, though, what's notable and what you should take away from this is the declines in 2008 in the last quarter or so, from September through December, in terms of both truck traffic and auto traffic. And in particular in auto traffic, you see a very steep decline in terms of autos entering the United States in the latter half of 2008. As I mentioned at the beginning, we did develop 4 metrics to provide a comparative perspective on border performance. I'm going to highlight 3 of these, and you just have to keep in mind that, in terms of our ranking system, number 1 was the most desirable position, and number 8 was the least desirable position. In terms of percentage change in total trade value, important points to note: the northern border average was negative 9%. That means that there was a 9% decrease in total trade value across the northern border. And again, you can see 5 out of the 8 ports examined actually experienced declines in total trade value, thus representative of that northern border-wide average of 9% decline in total trade value. In terms of dependency on manufacturing commodities, different ports of entry have different dependencies. Detroit clearly has the strongest dependency on manufacturing commodities, again, particularly because of its dependence on the auto industry. And we didn't find dependency on manufacturing commodities a good thing. We sort of viewed it as a more diversified commodity flow across the border is better in terms of resilience, particularly in economic bad times. So Detroit and Buffalo were numbers 1 and 2 with respect to their dependency on manufacturing commodities. And again, you can see how this is driving this bigger trend of decline in trade value along the northern border. Lastly, in terms of a percentage change in July through December car traffic, you can see that Detroit experienced the greatest decline in traffic during this period between 2007 and 2008. Auto traffic declined 16.2% compared to the same time frame in 2007 as 2008. Champlain was next. There's an entire northern border-wide average of a 7.3% decline in car traffic crossing the border when you look at 2007 and 2008. A lot of numbers. I know people aren't necessarily interested in data, and a lot of times your eyes glaze over. But what to take away from some of this data that I've shown you, decline, right? Declines in the value of trade, declines in auto and truck traffic across the border. And then, so for me and for my panelists, the interesting question I think is why? What are the drivers of these declines? And unfortunately, publicly available data don't lend themselves to pinpointing exact reasons for these declines across the border. We could argue that certainly the economic recession has had an impact on border flows. In particular, I think that governance, improper governance mechanisms have had an impact and actually is a driver of some of these downward trends that we are seeing in northern border trade. But most importantly, and this is what my colleagues are going to be discussing, we also think that the regulatory environment plays a critical role in these trends. And if policymakers and stakeholders are interested in reversing these trends, then action needs to be taken and thought needs to be given to the various regulations that are in place that service transaction costs and actually inhibit trade flows along the northern border. My colleagues will take it from here.
Well, I want you to stay here because I wanted you to take a few questions, if there were a few questions on this data. I would like to commend to everyone Catherine's article, The Border After 9/11, Security Trumps All. It's the clearest explanation I've seen of the bureaucratic battles in Washington, and having been a part of it myself, I think I can say it was just an excellent article, so I would really like to commend it to the group to read.
Is that on the front desk as a handout?
It isn't. I have my marked up copy here.
And there's a number that are being passed around as well.
Oh, good. No, not this. This is another one.
Yes, this is another article that, well,
I'll get you a copy
Yes.
if you're very interested.
I asked the articling students at the firm to bring me up to date because it's been 3 years since I've had hands-on experience with these border issues. So they produced for me this catalog of articles, which I did skim through most of them, and your article was one of the ones that they put out for me to read. Yes. So could we have a couple of questions? Are there? Yes, please.
Thank you. My name is Jim McElroy. I'm from Toronto. I'd like to commend you on this publication because thank you. It's got a lot of data and it's very easy to read even for someone like me. On page 3,
Our staff, we have a terrific staff who produced this.
I think it's very, very helpful data. On page 3, you had a slide up. It's on page 3 where you're showing the trade flows, the big picture with truck and rail. And what struck me is the red bars, as I understand it, those are Canadian, what we would call Canadian exports, you would call imports. Why are we using more rail? Canada uses more rail and less truck. Do you have any idea? That really struck me. I would have thought it'd be pretty well the same.
Well, I don't have an exact answer for you. I mean, I know broadly speaking, in terms of trends, the trucking industry in Canada is taking a real hit with regard to a lot of the post 9/11 measures that have been implemented, and it's something that they are very, very concerned about. So I do think that the regulatory environment has contributed to the decline in Canadian trucking exports to the United States over the past several years. I also think, though, too, and again, it's hard to pinpoint, but I think that the economy probably has something to do with it, less demand, perhaps, in the United States. But there are, again, a whole host of different reasons that one could point to that explain the decline in trucking and rail.
It's not because of trade mix that we're sending different things?
It could be. I mean,
Partly,
Sure.
Canada still exports a lot of bulk commodities, and rail's preferred for bulk commodities. That's the part.
yeah.
Okay, thank you.
Please, Michael, and we'll take
Very short. Could I please have 25 copies of this and 25 copies of that for my NAFTA class at Western? Because I gave them last year's, but I had to photocopy it in nice colors didn't come out.
No problem.
It's terrific.
Catherine, could you say something about, thank you very much, Bernard Hibbets from Pittsburgh. Could you say something about the situation of maritime shipping trade in comparison to the sort of land-based transactions and trade patterns you're talking about? And I'm thinking not only about the Great Lakes region, but also on the coasts. How does that fit? This is important then. I'm being somewhat facetious. I mean, I don't know. We have not gathered data on that particular segment. I mean, my limited knowledge of maritime shipping in the Great Lakes is that it has a lot of potential, and there are different forces and stakeholders at work trying to increase that as a mode of commercial exchange, but we've never examined it because my understanding is that it's still very, very small.
How about the coasts?
We have not.
Jones Act.
We have
Can't
not-
do it, only American ships.
Well,
Yeah.
just a question, Dan.
Hi, again, it's Dan Uto from here. Just on that question on maritime shipping, for maritime shipping, which a number of us do a great deal of work on, and I'm hesitant to even say anything sitting behind David Fung, who pretty much taught me everything I know about containerized shipping, but the reality is whether you're bringing it into the Asia-Pacific Gateway or to Halifax, you still need to figure out a place to get it into the Midwest, the heartland. I know, for example, Detroit is in extensive negotiations with Halifax. Cleveland just signed an MOU with Halifax on short sea shipping. Halifax, surprisingly, I'm pretty familiar with the globe, but Halifax is the closest North American port to southern China, southern Asia, including Vietnam. So it's actually quicker to bring goods in through Halifax. But Katie, I'm going to throw you the softball, your favorite topic. Could you just expand on your thought of governance issues? If you had to pick 3 next steps in terms of border governance, what would they be?
I think that the United States has to get its act together when it comes to governing the northern border. I think that the Canadian government gets it and gets the importance of the border. So I think that DHS has to start, as my article that Jessica referenced suggests. I mean, the reality is DHS is, driving the train. And so we have to work with what we have. And there is room in the DHS mission for the facilitation of legitimate trade and travel across the border. And I think that folks in that agency have to start focusing on that. In terms of a way to do that, I'm going to recommend on Monday that DHS establishes a northern border working group within DHS. So they have a working group established that focuses on the southern border. and recommending as a small governance measure that they establish this particular working group comprised of private sector individuals, other stakeholders, academics, people who have an interest in and a stake in the northern border, but not just based in Washington, from communities along the border, to help come up with strategies for better moving goods and services, or people, goods and services across the border. And then thirdly, in terms of the $64,000 question, what is the governance mechanism for North America? Stay tuned. I'm thinking about that, and I'm sort of torn between the regional approach, which we've advocated, which Chris has advocated, which seems to make sense, and the sort of the model put forth based upon NORAD, right? Like a North American Border Commission. Both have merits. There are trade-offs, and I'm sort of trying to weed through that and digest what I think is really the better alternative. So, thanks, Dan.
And for Tuesday's purposes, you just announced your recommendation for the northern border. 3 up to Mondays.
Cindy is next up, and she's going to do the most comprehensive presentation. So, David, she gets her full 15 minutes.
Yeah. Not 16.
Okay. I think we just need to switch the PowerPoint over as the tech.
Tech person is hiding there. There you go.
But I can start before it gets up on the screen. I'm talking today about the Canadian perspective of the top 10 distractions. And usually and normally, we start out thinking about what is it that the United States does that creates difficulties for Canadian goods getting into the U.S. And I thought, you know what, maybe this time I'll actually look at myself and the Canadian process and what the Canada Border Services Agency primarily does that limits access to the Canadian market. My first point is the buy local rules and buy America, so that's my one stayover from my negative list, but I hopefully have been allowed the mutuality on both sides of the border. And so my top 10 distraction list is buy local rules, the OFAC, Helms-Burton versus FEMA, the ITARs and dual national problem that we have up in Canada, anti-dumping cases in Canada, and a change in the methodology for calculating normal values, some of our judicial reviews and appeal processes, NAFTA verifications, advanced data element reports, border GST interest, harmonized sales tax in Ontario and British Columbia, and Canada's new subsequent proceeds D memo. And so my first 3 points are that I don't know where the border is at times. The border, this invisible border, seems to move. With the buy local issue, it's around states, it's around provinces, it's around local municipalities, because it started out with Buy America, that American companies were in the legislation to buy American goods, and it is how it was interpreted by states, how it was interpreted on a local level, and then there was a reciprocity in Canada with some provinces and some municipalities said, well, you know, trade's a two-way street, and if the road going south is shut down, we're going to shut down the northern road as well. So we had some municipalities come out and say, okay, well, we're going to have Buy Canada rules. So that moved the border around a smaller jurisdiction and what can get in and what can get in, mainly what can get into that jurisdiction, changed over the last few years, and we've got an agreement to work that out, but I find that that is one of the issues. And then we've got two issues with extraterritoriality, where I think that the border moves from the United States into Canada because the U.S. rules apply to Canadian companies, and we have two issues that arise from that. So on the buy local, we have on February 16th, 2010, an implementation of a Canada-U.S. agreement on government procurement, whereby the U.S. is going to waive the Buy America provisions under one of many statutes that has Buy America provisions. So it's only one statute, and it is limited in its duration. And the Canadian provinces are now scheduled to put schedules to the WTO agreement on government procurement. So we're heading in a direction. I don't think that this is going to solve all of the problems. And some of the problems were that U.S. companies weren't buying Canadian steel, weren't buying Canadian goods because they didn't want to have it in the warehouse, because if they were bidding on a government project, they would not be permitted to use that material. There may be some question as to whether or not they're sneaking the non-American goods in. And you know, as I previously mentioned, it led to a point of view in Canada whereby we were starting to do the same thing at a municipal level more than at a federal level or at a provincial level. There was the understanding by most in Canada that this was not the road to go. Another issue that we see come up quite regularly is the OFAC rules and Helms-Burton legislation, which is the anti-Cuba legislation, and OFAC goes further, which limits exports to certain jurisdictions, creates a problem for Canadian businesses when you're dealing with Cuba, because we've got the Foreign Extraterritorial Measures Act in Canada that says you should do business with Cuba, and if you are faced with a situation where you're being told by your U.S. parent or someone in the United States that you can't trade with Cuba, you have to let the Attorney General know in Canada, and you have to, you should trade with Cuba. And so we're seeing a lot more of this in Canada as a result of the huge fines that are being imposed under OFAC in the United States. And what we try to do as council in Canada is take a pro-business approach. The Foreign Extraterritorial Measures Act is all about finding a way for Canadian subsidiaries of U.S. companies and finding a way for Canadian companies to do business with Cuba. And from now with the fines, we're finding that, you know, in certain cases, the U.S. companies are saying, well, you know, have an end-use certificate and provide us with an end-use certificate, or we're asking you questions about where you're going to resell this product because it doesn't seem like something that you're going to use. Is it going to Cuba because of the red flag rules under the U.S. administration? And what Canadian Council is trying to do is to find a workable solution so that both laws can be complied with. Sometimes we're successful, and sometimes we're not successful, but I find that this is the border moving into Canada because the U.S. law is trumping what Canadians would otherwise do if you know, left to their own decision making. We also have a similar extraterritoriality rule with the ITARs, which is an export control piece of legislation in the U.S., where you're not allowed to allow individuals from a certain list of about 22 countries to have access to ITAR-controlled technical data or the goods that are controlled by the ITARs. And so people from China, from Iran, from Haiti, are just some of the few, Cuba, are some of the few listed countries. And what we have is a problem in Canada because Canadian companies are getting sued when we restrict the ability of an individual or an employee to have access to that information. They're saying we're being discriminated against on the basis of nationality. And they're taking this issue to the provincial human rights commissions in the provinces. And we have a number of cases, and in your materials I've listed the two cases. Suffice it to say, we've got Bell Helicopter Textron Canada Limited case, and we've also got the General Motors Defense case. And in both of these cases, there was a settlement as opposed to a decision that came out, but the settlement was on the basis that, yes, by restricting the access of this employee or group of employees to this data, or laying them off, or not hiring them in some cases, because they would be involved in projects that had ITAR-controlled data, that this was a breach of Canadian law, and some settlement payment of money needed to be made to these individuals. And so this is creating a problem for a number of Canadian companies and subsidiaries of U.S. suppliers, because there are Chinese nationals, there are Iranian nationals in Canada, or dual nationals, and they don't want to be restricted in what type of projects that they can be involved in. And it is a very fine line, working out a solution to this problem so that there is compliance with the U.S. laws and avoidance of the huge, huge fines, millions of dollars worth of fines that are happening in the U.S., and the Canadian human rights laws. And we actually went through this in our own firm because Lang Michener got registered with the Controlled Goods Directorate, and we had to determine what are we going to do and to comply with the law, and how can you even go around the firm asking, are you a dual national? Are you a Canadian? Or by any chance, are you from Iran? And we actually found that there are some people in our firm that had dual nationalities with the listed countries, and we had to devise a way to deal with this. And sometimes it's a very, very fine line to do this. Another, and the rest of my presentation is going to be things that the Canada Border Services Agency, or Canada, is doing that may irritate or distract the United States and United States business into Canada. And one is anti-dumping cases. Canada has orders against goods from the United States, and I'm not really going to focus on those. We don't have that many cases. There are only 4. And the 4th one is going through the process now, so we have 3 orders, and the 4th one may or may not be put in place. But Canada also has AD/CVD orders against goods from China, and then that's really what my focus is on here, because the U.S. companies are starting to get caught up in that. And we've done 2 things. Canada is different than the United States in that we have proactive duties, so that if we get a dumping margin or a normal value rate, and it applies on a going forward basis for everything that comes in after a particular date. In the United States, it's more retrospective, that there's a liquidation at a later point in time. And you're looking at whether or not, the United States is looking at whether or not they'll adopt the Canadian way, but we're very, very early in that process. With the anti-dumping duties, some of them are at like 170%, 240%, and then we've got the countervailing duty rate on top of that, which I don't think that there are many situations in the U.S. where you've got both anti-dumping and countervailing duties against goods from China. The U.S. companies that are most affected are distribution companies. And the distribution companies kind of think of Canada as one more state. We don't have a large, huge population. In fact, our population is similar to the population of California. And so they buy large bulk into the United States of these goods from China and then on-sell into Canada. So it is creating a problem for some of the U.S. companies, and we just changed our methodology in that we're no longer using really dumping margins as much as we used to, but we have normal values assigned to the exporters. And in the most recent fastener, which is the closest we can get to a widget, investigation of normal values that just ended a month ago, we applied Section 30, and what that means is that when we look at a U.S. company, we don't go to what was your cost of acquisition plus GS&A plus a reasonable profit. We look at that equation and what the dumping margin or normal values would be for the Chinese company, which is the worst, and that's what's going to apply. So it is creating a big issue for U.S. distribution companies, and it has affected the sales into Canada. Plus, we're not necessarily accepting that a trading company is an exporter for SEMA purposes. That's the Canada Border Services Agency position. We do have a Canadian International Trade Tribunal case called MCO, where they disagreed with the CBSA, but we have another number of cases going through the pipeline on that particular point. Judicial reviews and appeal is different in Canada, which is also causing a number of American companies some grief, and they're looking and saying, you know what, in the U.S. you just go to the CIT, and they're happy that it's a one-stop shop. In Canada, when you've got a dispute, you may have a judicial review going to the Federal Court of Appeal, or you may be going to the Federal Court Trial Division, and in some cases you have, you appeal your customs issue to the Canadian International Trade Tribunal, and you may have to take advantage of more than one remedy in order to, and I'm going to have to take another few minutes from you, David, just to get through this. But this is an issue that is coming up for Canadian companies. NAFTA verifications is another area where I think we have, a lot of issues at this point in time, because it's the low-hanging fruit. In this economy, look at certificates of origin. Are these NAFTA originating or not NAFTA originating? And so we have verifications going Canada down to the U.S. and U.S. up to Canada. And we're finding, and when they get to my desk, there's usually a problem in the application of the rules of origin and the specific rules that have been put in place in NAFTA. And what we haven't had at this point in time is we haven't had a review looking at where have we run into difficulties, and should we change some of these rules of origin that we thought that there would be an issue a number of, when we were drafting, but we now need to revisit it because I'm finding that U.S. companies are getting caught on imports into Canada where there isn't an interest in the U.S. that has a problem, and in Canada as well. These goods have to have the foreign content, but they're excluded by NAFTA. But you know what? There's enough U.S. activity that they really should be considered to be NAFTA originating, but would need a change to the rules to do so. And in the textile apparel area is one where I find quite regularly you're knocked out of the rules because of the fiber forward, yarn forward rules, which are extremely restrictive. And it is an area that, if we took the time to revisit it, the U.S. wants to increase their exports. This is the very first thing that I put on the list to do is, are our rules so restrictive after 15 years that, we're causing some of our own problems that we thought that there was a boogeyman and there wasn't one. Advanced data element reporting. Canada in, and that should be S2 as opposed to 5.2, passed legislation so that we can have our advanced data element reporting come by way of regulations. And right now we're in the process, but there's this veil of secrecy. We don't know what's happening. You call this 10+2 in the U.S. Well, I've got to tell you, it is entirely possible that our 10+2 is not going to be the same as the U.S. 10+2, and most of us don't know what is put in the list right now for the data elements. And then we have +3, which means all 3 modes are going to be covered by this data element reporting requirement, according to rumors, unlike the U.S. where it's only by land. We're actually talking about putting, it's owned by marine, we're actually talking about having air and land as well, which is significantly different, which will require significant computer changes and reporting changes and document changes in the U.S. if we go that way. Border interest, GST, we have a number of cases where there's no duty on the goods. And then Canada Border Services Agency comes in.
Okay, so what I'll do is we won't have questions on Cindy afterwards. We'll go directly into the next presentation, so you can take 3 more minutes.
And I just need 3 more minutes.
Okay.
And so for the border GSTs, we have a situation where the CBSA goes in, does a verification on value, decides that there's a different value methodology to be applied, which increases the value. So when you apply the GST at the 5%, and with HST it will be 13%, there's additional GST. You get that GST back, but there's an interest component because they say the GST should have been paid on day 1, and they're not waiving that interest. And I have about 3 or 4 cases going through the courts right now because of that. And one's over $1 million worth of border GST just because of a change in evaluation. We have the subsequent proceeds D-memo that came out last year, which is post-importation payments and fees, subsequent proceeds. And what you need to know about this particular D-memo is how it matches up with transfer pricing, that it's included management and administrative fees and other post-importation payments in the value for duty. So if there is a intercompany transfer price that's paid, the CBSA is going to take the point of view that this relates to the goods. And they're going to expect that an adjustment be made to the value for duty and additional duties to be paid. And they've made it quite clear that you have to satisfy 3 conditions. One is the services have to be rendered in respect of the operation of a business in Canada, and it can't be something that is just a percentage. So if you've got an administrative fee of 5%, you can't match it up to any particular services. They're going to say that this is in relation to the value for the goods. So that means that if the goods are not NAFTA, there's going to be additional duties, there will be additional GST, and then there will be that border GST that I spoke about. So this is a huge, huge issue that's looming with any intercompany payment that's made between a U.S. company and its subsidiary, obviously the subsidiary paying from Canada. The last thing I want to raise is on July 1, 2010, Ontario and British Columbia are going to be harmonizing their sales taxes with the GST. So there'll be 13% tax in British Columbia, 12% tax in BC, and Nova Scotia, New Brunswick, Newfoundland, Labrador is 13%. And after I submitted this slide to the organizers, Nova Scotia announced that they're going to be raising their GST, their HST rate by 2%. So Nova Scotia is now 15%. And Alberta, some people say they've got a 0% HST, so they're at 5%. And it's going to affect businesses in the U.S. that are currently registered for GST purposes, and because they're going to need to know the place of supply rules and the transition rules, so they start charging GST and HST on the goods and the services that they and intangible property. The place of supply rules have changed, and they changed on March 25th, 2010. We had until just a week ago to put in our submissions and our comments, so we don't have any regulations written. They're not exactly finished yet. And it's going to be a huge issue. Yes, David?
Cindy, thank you. I think you did a great job. Lauren, we'll have you next. Thank you.
Good morning, everyone. My name is Tenous. I'm the Vice President of Business Development at Stanley & Travis Trade Advisory Services. Some of the issues that we're talking about today are near and dear to my heart, simply because I was a Customs and Immigration Officer at the Ambassador Bridge from 1996 until 2003. So I was there pre-9/11, during 9/11, and then post-9/11. So I have a lot of experiences that are right on point. And as much as some of these regulatory regimes that we're talking about today can hinder trade, having firsthand experience, I can definitely attest to the need for some of these regimes. Unfortunately, if only we could have them work a little bit smoother than they're currently working, that would be good. So Cindy and I spoke earlier this week and decided that I could try and talk about the U.S. Legal and regulatory issues that we have that are hindering. I'm not going to go into too much detail. We have two programs specifically that I'll talk about and just give you brief updates on where we're at with them right now. The one is 10+2 and the other is CTPAT. Both of these programs can work symbiotically. There are a lot of benefits to them if they're used properly in terms of smoother flow of traffic for the goods and things like that. This past January, the enforcement began of 10+2 here in the U.S. What they have said is that it's going to be a gradual enforcement. It's not going to be, they're not taking a swift hand to things. Over the last few months and the next couple of months, they are going to be issuing certain letters, and they're not planning on going into full enforcement mode of this until October. They're hoping that with CBP is really doing their best to try and get out there and have educational outreach and explain to people what's going on so that they're prepared for this. I don't want to go into too much of the detail here. They're going to be issuing progress reports. Those progress reports are going to then, be used to mitigate, any violations later on down the road. They're planning on using those progress reports in this coming fall, when enforcement is going to be in full effect. CTPAT has been around for some time. I don't think everyone really appreciates the value that CTPAT can have, specifically for the trucks. I was an immigration lawyer before I'm doing what I'm doing right now, and the number of drivers that I would have come to me and ask me to help them become CTPAT certified was unbelievable. And I said, that's not what I do. I process, business immigration visas for people who want to come and invest in Canada. And they said, no, it's really difficult, and the company won't hire me because they're CTPAT certified. And so I was really, really surprised with the number of people that, were seeking that service. But again, with, the 10+2, the goal of CTPAT is to, better secure the whole supply chain. It's taking, I think, a longer time to educate people on what they need to do, but so far to date, CBP has validated 11,000 CTPAT numbers, and they've revalidated about 3,000. So the good thing with that is that, and I find this with our clients, that they say, and they'll come back to us after and they'll say, we're getting searched less than we were the year before, or the 2 years prior. And we thought you were just saying that, but they are really noticing the decrease of inspections at the border. So, and again, some of the benefits are that there's faster processing. There's, even if they are to be inspected, they get frontline treatment. And I mean, to me, this is similar to Nexus. I commute every day. I live in Windsor and I work in Farmington Hills. And I was adamant against getting a Nexus card for just personal reasons. I just didn't want all of my information going out there. And I would wait, and I would wait, and I would wait. And finally, I said, okay, this is taking too much time off of an already long commute. So I applied for Nexus, and I can't tell you the speed with which I cross through now every day, and it's really significant. So, I parallel this with that, right? The fast for the drivers. So again, CTPAT really prepares clients and importers for the ISF, and as I said earlier, there is a direct symbiotic relationship between them. And I find that even if there are violations, the CTPAT, even if they've started their application, it goes to mitigate things that come up later down the road. The other thing that I wanted to touch on today is I sit on the Michigan District Export Council, and they're really excited about President Obama's effort for the National Export Initiative, and they're saying, oh, we really need to work on this and get all these programs together, and it's great that they are trying to improve, double the exports over the next 5 years. What they're not taking into consideration is that we have hindrances at the border. We have export controls. We have, as Cindy mentioned, OFAC and ITAR and all of these issues that come into effect, and if people aren't educated enough on them, it's going to stop them, dead in their tracks. So, again, I don't want to go into too much detail here, but sort of just to bring us back, we were talking about the invisible border, exclamation mark, not question mark, and it's true, because if a company, if there's an entity that's owned or controlled, even foreign-owned subsidiaries of U.S. companies are subject to these OFAC fines, as Cindy mentioned, and so it's scary for them. But as I said earlier, there are reasons. I was there at the border. I get why they do this. We have to prevent terrorism. We have to protect security on both sides of the border. And Cindy was mentioning the fines. When I was looking through and I was collecting my data, I was shocked at the number of fines and how high some of them can go in terms of what people are getting, fined with, and they're for various things, as you can see. Some are OFAC, some are DDTC, some are the deemed export, and they vary. But there's definitely an issue for companies that are in Canada who are being affected by the U.S. Regime. That's it. I'm trying to get through. So.
Do we have any immediate questions before we open it up to the full panel? Okay. have prerogative for the chair, which means I can ask the first question, and I'm not going to in the interest of time. I have a short statement that I am going to submit to the record for the journal, which I'm not going to make here, but it does include the word imbecile. It comes out. Rick has his hand up.
My question is for Cindy. In 1992, when the Foreign Extraterritorial Measures Act passed, there was a great deal of chest beating and dismay by the government of Canada about Cuba Democracy Act, only outdone by the dismay of Helms-Burton. And great powers were given to the Canadian Attorney General. Could you tell us a bit about the enforcement history in Canada of the Foreign Extraterritorial Measures Act of 92 and 96?
I can tell you that you will not find any cases that went through the federal court system in Canada relating to FEMA. There have been a number of behind-the-scenes cases that have gone to the Attorney General where counsel and a number of the Canadian firms have worked cooperatively with the government counterparts to resolve the issue. But in a couple of the cases, and the two most famous cases, one's Walmart relating to the pajamas, and where Walmart U.S. told Walmart Canada to remove the Cuban pajamas from its racks. And so the Walmart Canada did so, and that caused the Attorney General to say, and then the Cuban pajamas came back. There's another case that an individual from Canada was prosecuted in the United States. I never pronounce his name right, but it's Sabali or something very close to that. And it was because of his activities relating to Cuba. There's also a Cuba Watch group in Canada that is active now and lets the government know when they hear of these sorts of issues that arise. So a couple cases have come to my desk as a result of this watch group. But what is done more, what Canadian counsel do across the board who do this is try and find a resolution to the issue, and for the most part, there is success of finding a way to address the issue without it getting blown out of control. And I think that it's managing the differences between the two pieces of legislation.
Can I have a follow-up question? Are you aware of any fines or prosecutions?
Am I aware of any fines or prosecutions by the Attorney General's office?
Yes.
I am aware of issues that have arisen that needed to be addressed.
Is that a no?
It's not a no, but it's not. It's very difficult. It's very difficult to discuss details because every resolution is subject to solicitor-client privilege.
Michael Robinson, I think I can amplify a bit that without giving any specifics, because it's come up on my watch too at my office. The rule of thumb appears to be this. There's two obligations. One, notify, and the other, don't obey the instructions, which include the word pressure, even, that come from the U.S. So what clients are doing is informing. And they file a notice and say, I've been pressured by the general counsel of the corporation, sent this to Canada and other banana republics. Here's what you have to do, and that's the law, i.e. don't have anything to do with Cuba. So you send a copy of that in, and the pile grows on the desk of the guy in charge in Ottawa. And he does not follow up and say, did you obey, but you're supposed to disobey this instruction? So the thing is, depending on your point of view, a non-issue or a festering boil. And as is usual in Canada-U.S. relations, it's going to be worked out diplomatically, I think. But there is quite a pile of those notifications, and I've instructed clients to notify, and they have done so, on the basis that probably nothing will happen. Does that help? You don't like that. You want action. You want lawsuits, convictions.
There's a question in the back.
Don Cameron. Cindy, you mentioned that in Canada you have a lot of simultaneous dumping and countervailing duty cases brought against Chinese respondents, and that the U.S. doesn't do that. I just wanted to point out that since I think probably about 2007 in the coded three-sheet paper, when the United States decided that yes, they could apply a countervailing duty to an NME country, which does create a number of legal problems in terms of double counting. But this is now the methodology du jour in the U.S., so that in most cases they are bringing cases under both countervailing duty cases on subsidies and NME dumping cases, so that we can get 600% margins, because that, of course, is a realistic number, right? But so it was just an observation.
Yeah, no, and I accept that there are some cases that have been coming through in the last 2 years. I think is really the time frame where you've got some cases here.
Dan?
Just thank you again. Those were, particularly the last two presentations as well as Katie's, were extremely informative as to what the current state of affairs is. And I think some of us, I actually have to do a presentation on Wednesday, so can I have your decks, by the way, to cut and paste from? But if I could give you two anecdotal pieces of evidence from what we hear on the ground every day for those of us that are in this business that deal with folks crossing the border. I certainly appreciate the level of CT pad verifications that are going forward. I understand Sam or Travis is encouraging those to sign up for them, because who do you have to go to get that verification? But we're hearing two things with CT pad Fast and the Trusted Traveler programs. The one issue is infrastructure. It's great to have a Nexus card, but if you're sitting in the Detroit-Windsor tunnel, hearing to get to the Nexus lane, you can be in a 2-hour lineup for that. I go back to even where there is infrastructure in, say, Blaine, Surrey. I think David and others were with us when we were in Blaine, where to get to the fast lane, there's 3 miles of fast protected lanes. It's the perfect infrastructure, and Katie, you were there as well. But then if they refer a truck to the vacuous lane, it cuts in front of the fast lane, and then you have trucks backed up for 3 hours as well. The other part is, beyond infrastructure, and I don't want to get into the Detroit River International Crossing, I'll leave that to others to discuss, but the other part is drug dealers, terrorists, or smart people. I spent 6.5 years around guns, drugs, and thugs in the federal court system, and they're innovative people. And RCMP, DHS, ICE, and others know that. So they're actually now inspecting CT pad and fast folks with increased frequency. Actually, we've had the officers say that. We look at CT pad now closer, because the drug dealers know if I go to a CT pad approved carrier, I can get my contraband through. So that's an issue that we're dealing with on a daily basis. All of that to say, we're constantly chasing the ball on the border. It's the next issue. What program do we create next? And it's time for the big picture. And I don't know if it's a NORAD type organization, or a customs union as other message, getting rid of the commercial border, those types of things all come around the perimeter and elsewhere. But if you had to pick, and I would direct this to Cindy and Lori in much the same vein as Katie, if you had to pick 3 things that our North American leaders would deal with in the fall, what would the 3 be that we need to fix X, Y, and Z, or Z for our American friends?
Can you do the first?
I already answered that.
Oh, you did?
My governance view.
Well, I think that what I'd like to see is we've got PIP up in Canada, which is Partners in Protection, which is the same as CTPAT, but Canadian companies aren't really getting signed up for PIP. That if there can be some mutuality, that would be extremely helpful. The number one thing that I would put on the list is actually for a thorough review of all the programs that have been implemented since 9/11, and because they're layered. And yes, the bad guys are getting smarter and smarter, but the question is, have the layers become so thick that the goods aren't able to get through, and that and has the cost become so extensive that it's actually hindering trade? And I think that the number one thing that I would recommend is to do a complete review and get rid of the layers or find ways to make this so it's not as costly, and from both a manpower perspective and from a business perspective, because in this economy, if you want to increase exports, if the United States wants to increase exports, if Canada wants to increase exports, we actually have to make it so that the goods can get through the border, and it's not so expensive to implement these programs, so that the costs get built into the goods, so that the goods are uncompetitive in foreign markets. So, that would be my number one and number two. And I'll let Katie do number three.
Well, did you? We'll go, Lauren, then I'll go. Okay. I mean, apart from the infrastructure issues, which I think are prominent, and I hear the same thing, and I see the same thing, the nexus lane is right here, and you're stuck, and if there's traffic, you're not going anywhere. It doesn't matter if you're nexus or not nexus. So, and I've been to the meetings of the chamber and, with the group, and we've had these discussions. So I definitely agree that that is one primary issue. The other issue, I would say that if they could hurry up and complete ACE. They started the project, it was supposed to be a single window, and it's just taken them so long to complete it. And so I think that their initial intent, where it's going to be, we were going to have one central place where the data was going to go in, and everybody was going to be using the same thing, not having to use the manual documents for various systems. I think that if they could complete that project, that would be on my top one list, or top three list, whatever you said.
And just to sort of wrap up, as I gave my governance spiel, but I think there has been progress. I mean, I think that the meetings at the highest levels of government taking place, twice a year between the Minister of Public Safety and the Secretary of Homeland Security, I think that's certainly a good start. I think it's extremely challenging because, as Jessica and I were talking earlier, what's happening at the northern border, in my view, is akin to a slow burn. Unlike September 11th, which was this shock, right? It was a one-time bam, wham, shock to the system, shock to the United States and Canada, shock to the border, and the ramifications were immediately felt and seen. What's happening now is happening slowly over time. You're seeing increased regulations, increased transaction costs, declines in flows, and the ramifications are much harder to pinpoint. A lot of people feel them, a lot of people know about it, but it's all happening underneath the radar screen. And I think because it's a slow burn, it's very, very difficult to get policymakers to turn their attention to something when they're looking at Afghanistan and Iraq and healthcare and seemingly more pressing issues. So it's not necessarily it doesn't answer your question directly, but I think sets forth some of the challenges in getting them to the table in the fall.
Another question over here.
Well, David Fong, I think if I could take a look at that and try something different, this is really what we do. Every time we get into the same track, we need to get out of that track. North America is the only continent in the world that uses regulations to stop the use of waterborne traffic. There's no other continent. You can go onto the Great Lakes, out in Cleveland Harbor, you look out there, it's quiet. There's no traffic. So we are the most stupid people in the whole world when we have the greenest way of moving products, and we would use regulation to stop it. So if I could ask the three of you or anybody else here, let us take do something bigger than what we have been doing. Okay? CBPAP, all these things are great things. But the border is thickening, the statistics are showing. But there's one huge traffic lane out there in the lakes that we are not using. What is stopping that is not Jones Act. What is stopping it is the U.S. Harbor Maintenance Act. So if I have a load of auto parts from TM offshore, it is 150 meters from the port of offshore, which we built together with the United States 50 years ago during the St. Lawrence Seaway. 19 ports we built on the St. Lawrence Seaway, and almost none of them are being used. Can you imagine that we invest into 19 ports and we use regulation to stop them all? So what do? The regulations of U.S. Harbor Maintenance Act imposes a levy based on the value of goods, not the tonnage of goods. So we rendered the world's biggest seaway into a commodity seaway only. So when General Motors put the goods onto a truck, one driver, one truck, go all the way several hundred kilometers to Windsor, Detroit, line up on Ambassador Bridge, and there's a ferry that crosses from Windsor to Detroit. But GM cannot afford to put that truck onto that ferry, because if they do, when it arrives on the other side, there is a U.S. Harbor Maintenance Act levy. This is a way of killing ourselves.
Yes.
So now, there must be vested interests who may be stopping us from doing that, but I think I'm looking towards our U.S. friends to say that let us, for once, turn those Great Lakes and our East Coast and West Coast to make them competitive traffic lanes. I can come in and provide you with one barge and put 300 TEUs or 150 40-foot containers on it, one custom clearance, and it's done. Okay. So I look forward to your comments on how can we move this logjam and create a whole new opportunity for us.
Great.
Laura, do you want to comment? Is this just a shake your head response?
Yeah, that's it. It's I
Yes.
agree.
Yes.
Agree.
Agree.
And my original list, as Jessica knows, had both the harbor maintenance fee on it and the APHIS fees as things that were border distraction/irritants between the Canada-U.S. context. And when I changed my list to be more Canadian focused, I of course took them off. But I agree wholly that some of these additional fees that are being put in place, I think primarily from a China-U.S. trade perspective to increase the cost of goods, it creates a problem.
Are there any more questions? Yes, Michael. David, you're not ringing any bells, so until you do, I would take
I'm
questions.
going to ring the bell at noon.
Okay, great.
Just add a small comment to what David said. David might want to talk to the chaps in Cleveland, who I think are still very keen on a project for a ferry between Cleveland and St. Thomas. Everybody says it's not going to happen, but if we could get rid of some of these silly charges, maybe it would. Anyway, there's keen people still trying to push that idea.
Do we have any more questions?
Just a comment, if you're looking for vested interest, Dr. Fung, you might start with a guy whose name is Manny. And also the son of Jimmy Hoffa.
Are they a team?
Well, it's the team
Manny Bird.
Yes.
I think since nobody's raising their hand, so maybe I'll make use of opportunity to make a suggestion that very often on the U.S. side, it was saying that because our ports are not equipped to handle containers, and so we need roll-on, roll-off. If you go to the Pearl River Delta, you'll find that that is a place, North America's ethnic Chinese community 50 years ago all came out of that one location because it's a location of perpetual famine. Until my uncle came in and put a little crane in every little port and turned them all into being container-capable ports. No roll-ons, no roll-offs. Roll-on, roll-offs cost you $7 million per port. My uncle did those for $500,000, and he would do it in the United States for $3 million.
There are two programs that I wanted to bring to people's attention. IE Canada sent me a notice, and on April 19th to the 21st, you can go on their website, especially for those who are more interested in technical issues. There is an Emerging Issues in Customs and Trade conference in Toronto. And then I know the Woodrow Wilson Canada Institute is having a panel in a couple of weeks on the drift between, are Canada and the U.S. drifting apart? And I know in your presentation, Kate, we talked about the economic causes for decrease of trade and traffic across the border. talks about trade diversification as being a cause, and that perhaps there may be now an irreversible trend with Canada shifting trade to other countries, and that might be something that we would want to look at as well. So I am going to conclude this conference 5 minutes early, and I'm going to
No bonus points.
with the suggestion that the girl band will probably have more recommendations coming out of this conference derived from this panel than from any other single panel. Thank you very much.
As we wrap up here before our final session, there's a little bit of a bait and switch on you here. What we're going to do is take a quick 5 to 7 minute break and then reconvene immediately for the wrap-up session. And then the luncheon today is more of a standing lunch and reception type area. So rather than go to lunch and bring things back and do that, we'll bring everything, come back here in about 7 minutes, or 10 minutes, I mean, is the reality. We'll do our wrap-up session, which will be to summarize what we've just heard over the last 2.5 days and plot the chart forward, and then we'll enjoy camaraderie over luncheon that'll be